Welcome one and all to the 2021 CIArb Australia annual lecture. I hope you can all see and hear us. If not, just please email the organisers and they'll try to get you connected. Thank you to Mark Lawyers and especially Damien Sturzaker, one of its partners and a council member of CIArb Australia, for hosting this year's CIArb Australia annual lecture. CIArb is delighted this year to have Brett Walker, AOSC, deliver our 2021 annual lecture, joining our previous eminent speakers. The title of Brett's lecture is Privacy or Secrecy: Open Justice Values as a Challenge to Arbitral Procedure. I am now honoured to introduce Mr. Walker. He was admitted to the New South Wales Bar and is a practitioner of the High Court of Australia in 1979. He was appointed senior counsel in 1993 and served as the president of the Law Council of Australia from 1997 to 1998, and later as the president of the New South Wales Bar Association from November 2001 to November 2003. Mr. Walker was Australia's inaugural independent national security legislation monitor from 2011 to 2014. Mr. Walker has served as a member of numerous councils and foundations, including the Board of Governors of the Law Foundation of New South Wales, various advisory committees to the Australian Law Reform Commission, and the Uniform Legal Services Council. He was editor of the New South Wales Law Reports for many years. Mr. Walker has been appointed to several inquiries as commissioner, including the Special Commission of Inquiry into Ferries 2007, and the South Australian Murray-Darling Basin Royal Commission. He was most recently appointed as Commissioner on the Special Commission of Inquiry into the Ruby Princess 2020. In the 2021 Australia Day's Honours list, he was made an Officer of the Order of Australia for distinguished service to the law through a range of roles, particularly to national security and civil liberties, and to professional legal associations. Mr. Walker, apart from his Sydney chambers at 5th floor St James Hall, has chambers at Maxwell 42, International Arbitration Chambers, Singapore. Welcome, Brett, and thank you for joining us today. Mr. Walker is happy to take questions at the end of the lecture via the Q&A function. Thank you, Brett.
Thank you, John. You're very kind. It was tempting to add those American-style descriptions to my chosen title for the remarks which follow. One could have been on not preaching to the choir. Another might have been on tilting at windmills. I don't doubt that the following argument will cut across presently consensus attitudes in the arbitration community. Nonetheless, as I will occasionally note, the concerns I will sketch are not mine alone. Time and space have not permitted as full and detailed and historical survey, which would desirably be global and thus multilingual, of the laws, customs and practices that are the real foundation of the topics I intend to touch on in my theme. It's not an exaggeration to see arbitration, after all, as a prime subject of legal anthropology, but I'll be excavating and speculating upon a mere fragment. My theme is the problematic nature of the secrecy of and about arbitral proceedings. So it's right to start by briefly acknowledging the vigorous tradition that, while probably preferring the more pleasant words private and confidential, has long seen what I call secrecy as a self-evident virtue, and I accept a long brandished selling point. Thus, Lord Diplock included the phrase "without publicity" in his characteristically sharp summary of the principal attractions of arbitration in Max Cooper and Sons and the University of New South Wales, a 1979 Privy Council decision from New South Wales. And probably more authoritatively in this jurisdiction, David Jackson of Queen's Counsel, Malcolm Holmes of Queen's Counsel, and Jonathan Redwood, now of Senior Counsel, as counsel for Akika, intervening in the 2011 High Court argument in Westport Insurance and Gordian Runoff, are noted as submitting, or perhaps asserting, simply that arbitration is by private agreement and is conducted in private. Such statements are legion. They are not, as I hope to show, always doctrinal as opposed to advertisement. We should probably regard the statement in the magisterial second edition of Mustel and Boyd as intrinsically of the doctrinal kind, or at least intended to be. That is, it's implicit in the nature of private arbitration that the proceedings are confidential and that strangers shall be excluded from the hearing. Note those distinguished authors' expression "shall be excluded" as opposed to "may be excluded." As you know, the usual basis for this supposed rule, which I doubt, is the contractual appointment of a tribunal with authority to regulate its own proceedings. To put it mildly, a basis built on sand and undermined by much legislation and international agreement, a matter I briefly return to later. I should disclose once and generally that I appeared as counsel in some of the High Court cases I refer to. The usual and adamant distinction between argument and opinion applies, as does the denial of ever being a sore loser. There is, I assume and hope, a typographical error in the foreword by the then President, to the current Akika rules. It boasts of some 35 billion Australian dollars in dispute, spread over what are described as 223 discrete arbitrations for 2016 to 2019. That's DISCREET, not, as I suppose should have happened, DISCRETE. The Freudian slip, I think, allows us all to see the point. As of course, in relation to that point, did the High Court in Reinhardt and Hancock Prospecting in 2019, which construed the scope of the agreed submission to arbitration expressly stipulated by the parties to be confidential. Questions of the possible outcomes of applying the separability principle and competens fell away because the agreed stipulation for confidentiality critically informed the interpretation of the words defining the arbitrator's jurisdiction, which was to decide disputes under the commercial family or family commercial deeds in question. Recitals included the previous resort by one of the parties to what were called sensationalist media and the potential for that party negatively seeking exposure to the public. The resources development commerce in question was very obviously conducted so as to require much use from time to time of information that had to be kept confidential. The dispute clause had been held in other litigation by the New South Wales Court of Appeal to exclude disputes about the validity of the deed itself. Contextually, the High Court oppositely held that they could not, those clauses, be understood as providing for determination of the issues in the public spotlight. Such was, in particular, the significance of the need for commercial confidence. It was inconceivable that the parties would have thought claims concerning the validity of the deed involving trusts and raising allegations such as undue influence were to be heard and determined publicly in open court, as opposed to confidential dispute resolution. Now, my point is that the High Court was construing a private bargain involving little, if any, public interest between the parties and no issues of public funds. Pacta sunt servanda, a maxim especially evocative in modern arbitration, procedurally as well as substantively. The truly discreet, confidential and private nature of arbitration, agreed so to be conducted, is, I think, on any view, a very attractive aspect of contractual submission to arbitration, especially when the submission is agreed before any disputes have arisen. When the threat of public exposure, that is, of alleged wrongdoing, may loom as large for one party as for the other. Leaving the question of secrecy to await an actual dispute arising obviously creates the risk that one party may thereby obtain a negotiating advantage over the other, if the other can then be clearly seen to have more at risk from a publicly reported adjudication process. On the other hand, litigation in court virtually always places the parties in the public glare. Again, that exposure quite often is more damaging for one party than the other. But no one surely regards that imbalance as unfair or against the interests of justice. To the contrary, the public decision-making that one of the two disputing parties was in the wrong, perhaps in discreditable ways, is part and parcel of the open court defining characteristic of the administration of justice in our system. The educative force of declared and enforced legal rights and obligations is an essential part of the rule of law. It does need to be seen and heard. It may be that the repeated observation that arbitration is somehow conceptually distinct from litigation in a fundamental way by being based in a private bargain as opposed to the compulsion of the state is much overdone. While noting that arbitration lacks distinctive hallmarks of the exercise of judicial power, including the maintenance of public confidence in the manner of the exercise of that power, the High Court in Westport and Gordian in 2011 held it was going too far to conclude that performance of the arbitral function was purely a private matter of contract, wholly divorced from the exercise of public authority. Now, that was part of the reasoning concerning the standard of arbitral reasons when it was possible in those days to challenge on an award for manifest error on the face of the award. In a case involving the application of a public statute, then regulating the relations of insurers and reinsurers. The case raised what might once have been called an oil basins point. In this regard, comparison of arbitration with litigation was used by the High Court to shape the proper approach to a very important aspect of modern arbitration, namely the provision and standard of reasons for the award. That mode of requiring accountability of the tribunal was regarded as not implying a radically different, let alone opposite, approach as between arbitration and litigation. True, much turned in that case on the ultimate supervision of the arbitration by the court. However, even in the now much less judicialised world of the UNCITRAL model law, these very observations in Westport were called in aid and cited by the High Court in 2013 in TCL Air Conditioning and the judges of the Federal Court of Australia. Of course, that decision very plainly contrasted the exercise of judicial power in the courts with the arbitration of disputes, which was held to lack the essential foundation for the existence of judicial power. In another and very practical context, in GIO New South Wales and Atkinson Leighton joint venture, the High Court had earlier in 1981, by a bare majority with Chief Justice Barwick dissenting and Justices Mason and Stephen giving reasons for the majority, it was held that arbitrators had power to include interest in the award in the absence of any express term in that case of any such term to that effect in the submission. Strikingly, the majority reasons drew substantially on a governing analogy, as their honour saw it, between the courts and arbitrators. That is, Both were applying the law of the land to decide the disputes before them. And statutory powers specified to be available for courts to give prejudgment interest were to be seen, said Sir Anthony and Sir Ninian, in that guise. Sir Ninian invoked the normative assertion that the claimant should be able to obtain from arbitrators just such rights and remedies as would have been available in a court of law, referring to an arbitrator's implied authority to follow the ordinary rules of law. I ask, how does such an analogy give a statutory power enacted for courts to include interest in their judgments, which could be repealed tomorrow, become the law of the land to be enforced by arbitrators, without suggesting other attributes of the courts also should inform, if not dictate, the practice of arbitrators? Procedural fairness is probably the least contentious of such suggested parallels, answering to our deep intuitions about justice. But it's not the publicity of hearings, that is not the publicity of hearings and decisions, an attribute of all justice, deep enough to be called open justice as a defining or essential quality of at least judicial dispute resolution. Sir Anthony Mason in GAO and Atkinson Leighton proceeded by a contractual term implied in the submission to arbitration, again by positing the scope of relief in court as the measure of an implied scope of arbitral relief, relying on the parties' contemplation that their differences would be arbitrated in light of the general law applicable to the subject matter, including the then recent enactment of the court's power to include interest in their judgments. Respectfully, if the question was whether the arbitral tribunal had the power that Parliament had given to courts, using an affirmative answer to justify itself is somewhat dubious. Of course, the result is most convenient and commercial, and none the worse for that. A final remark about High Court approaches to features of arbitration relevant to my thing. In Esso Arbitration Resources and Ploughman in 1995, the court had to choose between very different contentions as to the importance of the related but not identical features of privacy, say, of hearings, and confidentiality, say, of information and documents. The notion of a near equivalence in regime to what we call the Harman undertaking in courts was at the heart of the dispute in the High Court. It's to be remembered, mind you, that the Harman undertaking confines the use the parties to litigation may make of that which has been produced compulsorily to them by other parties. And it is an undertaking that expires as soon as the material is tendered into evidence or into open court, as the cliche has it, subject, of course, to special orders. And the undertaking can be dissolved by subsequent application to the court itself. Neither of those aspects were embraced by the SOBHB Bass Strait parties before the High Court, although they obviously had to concede the availability of disclosure to the minister, etc., as required by statute. They were public utilities, the state gas companies, against whom SOBHB were pitted in a pricing arbitration. The engagement of public and political interest was obvious in a case that would affect retail gas prices. Chief Justice Mason considered whether the course of evolution from the right of parties to private hearings of their arbitration, including in the sense of no right of members of the public to attend, to that benefit of arbitration producing a further essential attribute of confidentiality, or secrecy as I would term it. Not least because complete confidentiality could not be assured, and also because principal exceptions were elusive in articulation. Sir Anthony rejected this role for confidentiality. It would be otherwise, of course, His Honour held, if the parties had expressly agreed to that state of affairs. Sir Gerard Brennan agreed, adding useful examples of situations antithetical to complete confidentiality, such as when there is communication within corporate groups. CIArb pointedly regarded the public's real interest in the gas arbitration's outcome as producing what His Honour called at least a moral duty for the utilities to account to the public for the manner in which they perform their functions. This then is a strong case when confronting the contemporary reflex in arbitration practice that condemns the very idea of publishing evidence and argument. Perhaps that reflex is why, as noted by Professor Luke Nottage, Plowman has been regarded by some as controversial, and as well why arbitration rules have iteratively, though not very consistently, addressed the issues of variously prima facie, presumptive, or even mandatory secrecy of arbitral processes. I cannot survey this fascinating tangent of legal anthropology, and I commend to you the various reports and reflections by, among others, Professor Nottage and his colleagues, and of course, Doug Jones, concerning what is nowadays called transparency and the institutional arbitral responses for and against its increase. In particular, Chief Justice Menon's formidable challenges in his 2020 CIAC address, now published under the two-edged title, Arbitration's Blade, International Arbitration and the Rule of Law, include serious and substantial warnings not to regard, as it were by unexamining default, secrecy as a necessary virtue of arbitration. Before concluding with some practical suggestions, some further description, perhaps it may be analysis, is appropriate in relation to secret as opposed to open justice. Note my assumption that arbitration is part of a social, now global project of justice in the particular sense of peaceful settling of civil disagreements according to law. Crime, of necessity one hopes, will never be treated the same way as the cases in which arbitral secrecy has become the customary norm. The ever-expanding to date field of arbitral disputes and the rules to decide them in arbitration is a strain somewhat for the traditional private contract contrast with the state power jurisdiction of the courts. Many legislated norms, often well outside previous substantive law, are now regarded as easily within the scope of arbitral matters. Depending on the jurisdiction in question around the world, the once virtual confinement to contract has swelled to include tortious and equitable claims, albeit most commonly those agreed to bear an acceptable relation to the contract containing the submission, but also trusts and corporations, even matrimonial property disputes. Ad hoc arbitration agreements almost certainly can extend very broadly, encompassing torts on their own, intellectual property disputes, as well as the ever-present disputes concerning allegedly misleading and deceptive commercial conduct under various statutes. All this seems to me a most welcome liberality of arbitral jurisdiction, that is, in the interests of justice and for the courts to foster. On the other hand, apart from crime and constitutional and judicial review, which supervises the legality of governmental action, there remains non-arbitral fields of dispute that remain the unshared duty of the courts to determine. The interests of incapable persons and children are paramount examples. And it should be noted, traditionally also, exceptions to open justice and statutory and some equitable powers that, even in civil disputation, require weight being given to the public interest or the possibility of liberty to apply for further judicial supervision, are non-arbitral very often. But importantly, all the more strongly shown as needing to be heard and determined openly in public. Perhaps we can discern the fitness of secrecy as an attribute of arbitration by comparing it with some well-established exceptions to the open justice characteristically administered in courts. A prime example concerns trade secrets and the like, where publicity destroys the very subject matter being litigated, an exception that proves the rule, lest justice engender injustice. The common or garden confidentiality of most business affairs involve no such threatened perversity when it yields, as it does every day in courts, to litigious procedures and the publicity of judicial findings. And growing occasions for market disclosure reminds us that there are more than private interests involved in the commercial disputes of listed entities. Similarly, the shame of systemic delinquencies in corporate conduct, including from dealings with customers and consumers, such as may be exposed in so-called class actions in court, have long been the subject of admittedly patchy prohibition of compulsory arbitration in contracts of adhesion. The rule of law and justice are both better served by the open adjudication of such matters. It need hardly be said, furthermore, that commercial corporations of the kind that comprise most of the parties to arbitrations have little in common with children and the mentally ill or disabled, and their affairs scarcely resemble marital unhappiness, at least so far as concerns the compassionate delicacy that may be appropriate in reporting them or not reporting them. I come now to the area of domestic arbitration where, in my opinion, the secrecy of proceedings is very far from virtuous. Unfortunately, it's quite a large segment of the market for arbitration. I'm speaking, as you've probably guessed, of what may generally be called public or government procurement contracts and their related disputes. Nowadays, it often consists of large infrastructure projects, all manner of civil engineering and construction, as well as plant and fleet acquisitions, maintenance and operations. And just to be topical, other endeavours that may be funded by consolidated revenue or taxes or public charges include testing for infections, carrying out vaccinations, running quarantine facilities, disinfecting premises, etc. In such cases, if you'll forgive my cynicism, the incentives for all parties to conspire, I should say agree, I suppose, to keep the public uninformed can be very urgent. Poor engineering on the one part, poor administration on the other part, may be true of the private contractor and the public agency at the same time. Both states of affairs are apt to cost money, including, in many cases, public funds. The public have the best and most significant social and ethical claim to information about the expenditure of public funds. Good public servants and officials, accordingly, also have an excellent claims for the efficiency in the public interest of their right to obtain information about a bidder's real track record, including frankness of dealings when the going gets tough. A large builder, say, simply should not be able to say it's a problem-solving cooperative provider of useful services if that is shown by recent disputation simply not to be true. At present, such a party could rely on the secrecy of arbitrations to keep discreet about the last ugly brawl with another public agency. And the grapevine is a really cynical solution to this problem, because the grapevine typically spreads either behind hands or among cronies. If anything, like court openness, public access to arbitral proceedings involving any substantial call on public monies seems calculated to improve pre-dispute behaviour. At least it would be a worthy experiment. There are, from the nature of things and paralleling the position in courts, two cardinal exceptions. First, there's real public interest immunity, such as when national security is involved. And in my experience, that is observed. Indeed, it can't properly be waived in court proceedings and therefore must always be equally treated in arbitral proceedings unless we risk an absurdity. Second, genuinely current competitive information is frequently protected by redaction and non-disclosure orders in court, usually sensibly so. The corresponding public sector interest, naturally, is the safeguarding of the integrity of the tender process and similar processes for public procurement. That safeguarding will often justify the non-publication of competing bids, even sometimes well after the eventual award. But these are all matters of public interest in a proper level of competition in markets generally and for public procurement in particular. The fact that the Auditor General can investigate public procurement, including when disputes have been arbitrated, rather makes my point. Except to those, of course, who've absorbed the subtle poison of regarding the business of business as nobody else's business, not even of the people who are paying the bills. A real obstacle to reform in the direction of prohibiting secret arbitration of public procurement disputes is that governments and their advisors, the same cadre of officials and consultants whose support would nearly always be essential for such a legislative project, are the very people most enthusiastic in their wielding of the most overused metaphorical rubber stamp, the one that growls commercial in confidence, the one that's being used as we speak to repel all sorts of legitimate inquiries for information about government. First, then, a culture change among the mandarins. It should be straightforward. Next, we come to an area where the politics have worked to produce reform in the desirable direction of transparency in the interests of public access to basic governmental information. Investor-state dispute settlement under various international treaties, usually bilateral, have produced very justifiable angst about the milieu of secrecy. After all, the outcome of such disputes could override national legislation and regulation at the behest of foreign interests and not by a panel of Australian judges. In fact, former Chief Justice French's powerful contribution to what might be called a debate of protest about it is one of the seeds for the interest that has engendered my remarks in this address. Professor Nottage has also prominently drawn attention to the global diversity, to put it mildly, of law and practice in this regard, and cautioned in particular about the substance of real change in international arbitrations in this country as a result of the 2018 statutory amendments in this direction. I agree with Luke Nottage, but nonetheless, I greatly welcome a resurgence of what might be called a national spirit, and we're not alone among nations, to prevent our laws being nullified by a secret, non-accountable tribunal. I'm sorry if that sounds like QAnon, which would be the opposite of what I intend, of course. The accountability created by open justice is at the price of spectacle, audio, visual, feed or recording, I suppose, nowadays. But this is not an unreasonable price to pay. Spectacle includes the real-time display also of apparent impartiality, argumentative cogency, and decisional wisdom. And if it doesn't, all the better for such deficiencies to be displayed. In the cases where arbitration proceedings should not be secret, or the parties refreshingly forego their prerogative to contract for secrecy, there's never been a better time for the profession to participate in a most useful way. I refer to our combined experience, judges, litigators, advocates, arbitrators, not to mention parties and witnesses, since the virus upended our ordinary ways. Remote hearings, with all their glitches, permit fairly generous real-time public access, fairly well developed in our superior courts. Live feed is no longer what they call a session at the zoo. It's now how the public can participate as the public with its proper interests in the arm of government, which is the administration of justice. Arbitration should be seen as dispute resolution in its adjunct form, not separate or insulated from what the courts do. And what the courts do includes, of course, enforcing arbitral awards. So open arbitrations don't involve much added expense, if any. You won't need to hire the Opera House. Before concluding this litany of doubt concerning the virtues of secret arbitration, I venture a thought experiment. If that secrecy is such a valuable and appropriate feature of dispute resolution by arbitration, why don't the superior commercial courts of this country also adopt it or offer it competitively? Now, you can't answer that question by saying that the courts mustn't do so because that would eliminate a competitive advantage of arbitrations. Self-interest only goes so far, at least acceptably. Do you think the courts will make this change, perhaps to oblige or please commercial personages? Should or could the Supreme Court increase the fees and charges for the added facility of keeping the public and its journalists away? A bit like private boxes at the opera. If so, why not for all kinds of cases? If so, is open justice then to be available or inflicted only to or upon those without the funds to buy their way out of its publicity? How would that be an increase in social solidarity and its particular aspect of equality before the law? Or is that also to be downgraded? Obviously, I hope the experiment shows that an open court is not some atavistic or, as some would think worse, idealistic attribute of some outdated aspirational model for peaceable dispute resolution. If I'm right in that, we need to ask ourselves whether, as we lawyers love to say, we've got the balance right when it comes to open or secret arbitrations. More specific questions can await practical steps towards opening arbitrations. The not entirely effective use of pseudonyms in the family court and in criminal cases and wardship proceedings about children would no doubt be considered for what it may contribute to procedural safeguards. Legal force, on the other hand, for non-disclosure orders would not be too hard. I close with a quotation from Luke Nottage, Julia Driosti and Robert Tang in the Journal of International Arbitration last month. I envy their polite diction in describing an ugly truth about our profession as well as others. They say, and I adapt, confidentiality, which may reduce costs and delay, also, and I quote, exacerbates the information asymmetries characteristic of most services markets, unquote. What a polite way of saying, if people can't read, see, and hear you in action, they probably won't know as much about your merits or otherwise as they might, had they been able to read, see, and hear you in action. Some may say the bleeding obvious, but I would join those learned authors in saying a very important combination of policy and principle in favour of the openness of dispute resolution proceedings. On the bright side, for arbitrators and lawyers involved in arbitration. In my experience, the ability for others, even the public at large, to see and observe your qualities is really very likely to enhance your standing. And it may even, let's hope, speed up some of the less brisk, shall we say, passages in some arbitral proceedings that I'm sure many of us can bring to mind. Thank you very much for listening.
Well, thank you very much, Brett, for what has obviously been a provocative and thoughtful examination of the chosen topic. I certainly have questions, and I want to open the floor via the Q&A function for those who wanted to pose some questions. We've obviously got a large audience of people, many of them arbitration practitioners, and what you've done this evening is to challenge established norms, which is exactly what we were hoping you would do. I might kick off with a question, and it harks back to one of the topics that you touched on, which is investor state. Given some of the publicly voiced concerns in relation to some of the large investor state claims, do you think that, if you like, that provides a wedge for a move away from confidentiality and privacy of arbitration proceedings? And is that something that one will find that will be used by advocates such as yourself, moving away from privacy or security?
Well, I've used it, as you've heard tonight, I hope not as a wedge, because I wouldn't intend that the principles and public policy that are important to investor state disputes should extend outside truly analogous areas. But you will see that it's the public interest of people, if you'll forgive the language, the people in government, that informs both the objections that I certainly share to secret exit arbitrations. That is in common with a concern I have at a much more domestic level, but probably more important for most people most of the time, which is just what were the arrangements for the, say, huge payoff to those who carried out the light rail in Sydney. Those are really important political issues. Votes may change according to that. Bit odd to have one of the precious few implied provisions of the Commonwealth Constitution, implied freedom of political communication, if the law assists a ready source of information about really important matters of government being disclosed to the public. What happens if there's a dispute about the process of raising Warragamba Dam, for example?
Do you find it also curious to have a situation, say, with Philip Morris, which obviously was exposed, the various aspects of Philip Morris were investigated in some detail before the High Court, and yet the investor state arbitration with Philip Morris was largely secret?
Yes, well, I remember that litigation. I thought that there was an almost grotesque imbalance between the complete transparency of the High Court proceedings and the really inappropriate, ugly, confronting secrecy of the arbitral proceedings. We should all be very relieved, in one sense, that it went off on a jurisdictional ground, because had it gone to what I'll call, using the expression loosely, the merits, then there would have been, I think, a really, really bad day for Australian government.
Yes, and in fact, I think John, Arthur might like to pick up on a question that's been posed on the same topic, but a different arbitration litigation dispute. John?
Yes, we've got some questions, Brett, on the Q&A function, and the first one that was posted is, what is your view of the decision of WA to overturn the Palmer domestic arbitration award from the perspective of international business optics?
My view is that the badge it now wears of constitutionality is likely to go some real distance to persuading governmental counterparties globally that there is not much to see here. After all, there is a common theme to governments, however different their ideologies might be, and they all like to govern. So being told that in Australia, it's the government that will ultimately decide such things through its legislature won't offend many other governments. Will it be the kind of moral hazard that puts people off investing in Western Australia? I'm not being cynical when I say I think the quality of the hematite will be rather more telling.
A question that you may be able to answer, really just because of the secrecy involved, but a question put by Kieran Pender is, to the extent you're able to answer, has your involvement in the Kaleri secrecy appeal shaped your views on the relative merits of secrecy and openness in judicial and arbitral proceedings?
As soon as you said Kieran's name, I knew that. And hello, Kieran. Listen, I had the odd view about such matters before I argued Kaleri. And no, I'm not presently at liberty to talk about reasons in Kaleri, although the latest bulletin as of today is that either agreement or an argument about a redacted version for publication is imminent. I have very strong views, matured, I suspect, by my experience as the monitor, about the ways in which we may imaginatively try to have court proceedings look at material which would otherwise be embargoed under public interest immunity. Different countries have tried different expedients, and they're not all very attractive from the point of view of open justice. Australia's NSI Act is characteristically complex. Tony Willey has been heard to observe that its complexity has been its great virtue because no one wants to argue it, and so they settle, which may actually be a practical advantage of Australian form puzzle-making statutes. But seriously, it does seem to me that what Kaleri is just the most recent emphasis of is that there is a definitional feature of the administration of justice that you can see it being done. Now, it's not quite watching the sausages being made, but it needs to be closer to that than most other governmental functions. I can understand why we don't have webcams in judges' chambers, let alone in their conference rooms. But otherwise, you do see and hear judges deal with counsel, and you see their reasons, which they're not allowed to monkey around with. Parche, what the US Supreme Court has been doing for some decades. So all of that is a form of accountability for people who obviously otherwise have very secure and protected positions. Judicial tenure is a constant background against which one needs to understand accountability of judges. If you combine secrecy with judicial tenure, I, for one, would be unlikely to think of highly as the judiciary as I presently do.
Perhaps we've got another question, Brent, if we could. What impact do you foresee open arbitrations having on arbitrators and their preparedness to take on the role of arbitrator, knowing that their awards will or could be open to public scrutiny?
Well, for those arbitrators, not a few of them, who used to be barristers, no doubt their shy and retiring nature will mean that they'll be most embarrassed about ever being seen to work in public. Not. So I can think of the odd former barrister, now arbitrator, usually with an intervening stint as a judge, who would be completely unfazed by applying their trade in public, perhaps at the Opera House. Now, that's a serious answer, facetiously framed. My own view, and it is a barrister's view, 42 years of practice, is that it is not a bad thing. It is a good thing that whatever I feel like, I do have to turn up in court. And nowadays, not just the people in the courtroom, but live feed from God knows where can follow what I'm saying and will have read my written submissions beforehand. Now, if that sort of thing worried you, then I guess the best answer is don't practice litigation, particularly as a barrister. But seriously, I do not understand that we should be worried about some segment of the possible candidates to be arbitrators of people who don't like to have their work in real time witnessed. Surgeons are used to having other people in the operating theatre. It's not a bad idea, you know, because it could help to stop accidents or worse. Well, the analogy is not exact, but it's got the legal profession and the arbitral community ought to see itself in the same high-minded joint endeavour in adversarial setting, true, to get things right. And you do help to get each other right by there being a pervasive sentiment that anything that's out of what might be called acceptable norms will be noted as such, and not just by your mates in the arbitration itself, but by your colleagues, friendly and unfriendly, as well as your customers. Now, I think that is 100% a good thing. I understand the view that shudders at it, but I just say, relax into it. It's fun.
Brett, this is a follow-up question from me, but in circumstances where all the surveys going back to time immemorial cite that confidentiality is such an important component for the reason for arbitration, I guess, first of all, what impact do you think, if you did strip away or at least limit confidentiality in the context of arbitration, what impact do you think it would have for the attractiveness of arbitration over litigation for certain types of disputes?
Well, that's a great question. And they are matters that I did give consideration to including in my remarks, but it would have doubled the speech in length. It's all crystal ball, but in my view, there would be some henny penny sky falling down immediate reaction. And then I think nearly everyone who makes decisions with dollars attached in this area would ask themselves, just what are they losing? And don't forget, I'm not talking, there are many arbitrations that would still, in my view, be by agreement of the parties, secret. And I have no problem with that at all. Just as I hope mediations will continue to have as one of their qualities secrecy. I cannot imagine mediating on live television. So I have no difficulty with cases that can be kept confidential being kept confidential, and that'll be quite a few cases. But cases that ought not to be confidential for the principal reasons I've urged are cases where I doubt whether seasoned arbitration practitioners would see much being lost either by them, nothing really, except the chance to strut their stuff, and it's really not much by their clients. But let me divide the clients into two. The public sector clients, I'm not interested in what they think. I'm sick of what they think in this area. They have been concealing information that we the people should have for generations. So I couldn't care less about what they think. I would not consult them about any of this. I did say tilting at windmills. But as to the commercial counterparties, the big contracting firms, there will be a culture change necessary, and I don't underestimate the difficulty of it. I think, however, and here's a systemic stepping back view of it all, that one of the more interesting questions is, maybe losing secrecy would mean that more effort and more success would be necessary in the supposedly lower costs and the supposedly shorter times that arbitration supposedly offers as its superior mode of dispute resolution over litigation in court. Most of us now have experienced death's head examples of the opposite comparison. And none of us should kid ourselves that our commercial clients invariably prefer an arbitral panel of 3 in proceedings strung out over 18 months, and in the old days involving people sitting up the front of aeroplanes over a brisk outing before David Hammerschlag, who lets his opinions be known in his robust way.
Very true. It's very, very true. Unless there's a question from John, a final question from me. Do you think, oh, sorry, John.
Well, we've got one question from an attendee,
Sure.
Jordan Lee Ditloff. Mr. Walker, I detect in your address a distinct disdain for what might be called the transnationalist tendency or school of thought that seems to persist or exist within arbitral schools of thought and sometimes institutions. In what way do you see, as you alluded to, that such ambitions represent a potential threat to traditional national court jurisdictions?
It's a very interesting question, and another one of those topics that I could really have, and I was thinking about devoting a lot more time to, was the last one to be discarded. No, I'm not actually disdainful, far from it. I'm interested in, but not disdainful of what can be fairly called transnational tendencies. I'm sufficiently a 19th century ameliorist as still to think very kindly and warmly about attempts not to eliminate national and cultural differences, but to bridge them by working out common ways of proceeding by people who still remain proud and adept practitioners in their own national systems. And I think, with respect, that arbitration has been almost successful as soccer in that regard. It's been pretty good. And the fact that its techniques, and if I might call them this, its values or ideals, have continued to be exercised in true international, by which I mean diplomatic relations, as well as international, transnational commercial dealings, as well as in investor state, to use the new jargon, is, I think, a pretty clear demonstration that the transnational tendency is no bad thing, but what sometimes is called lowest common denominator or jurisprudence by blender are both things which I just abominate. I don't have a lot of experience, some, but not a lot, of amiable compositeur or ex aequo et bono. And I share an old-fashioned barrister's rule of law disdain for palm tree justice. Palm tree justice is great if you have got either an expert determination or a third-party arbiter of a kind that I and quite a few of my colleagues are from time to time in commercial disputes, which is exactly when the parties don't want reasons and don't want to know anything other than. My favourite one was a form where I had to tick a box or not, and there was in bold type at the bottom, if you do anything else, you won't be paid. That was dispute resolution. But seriously, arbitration is a form of reasoned, according to law mostly, dispute resolution, and it would have no continuing market, including transnationally, if it was all just throw it up in the air and see what somebody who seems to have good CV thinks about it. That has no future as a market for professional services, but more to the point, as a contribution to civilized life. And civilized life means the peaceable settling of disputes, not least in order that good trade can be fostered and bad trade can be limited. So no, I'm not against transnationalism, but I make no bones about it. That doesn't mean that I belong to the anything goes, I must never, ever suggest that I think say that the Anglo-American Australian system is a bad one, because I don't.
Excellent.
Thank you.
Well, with that final answer, it falls to me on behalf of Mark Lawyers and obviously on behalf of the Chartered Institute to thank Brett. Many years ago, I sat at a conference shortly after SO and Ploughman had been decided, and an interjector from the floor asked a question to the panel, and he was an expatriate Australian who'd been spending a lot of time in Italy, and he asked a question, and he pointed out the damage that had been done to Australia's reputation with the decision in SO and Ploughman, and the fact that no one will arbitrate here ever again because the key element in arbitration is secrecy, and he made those statements in very strong terms. And what he hadn't taken account of was that Sir Anthony Mason, who, as Brett had indicated earlier, sat as the Chief Justice on the High Court that decided that point. And Sir Anthony took offence and responded in kind. So you could imagine that here we are 24 or so years on, and we're revisiting some of the essential questions that the High Court was asking back then about how essential an element is privacy or secrecy in relation to arbitration, and how should they be differentiated. And Brett, as one would expect of someone with not only his historical background, but his recent background as a national security monitor, is someone that asks serious questions of the circumstances in which secrecy is a necessary component of justice or of open government. And I think very cleverly, what he has done is identified particular circumstances in which those questions need to be posed, particularly in relation to contracts of adhesion, particularly in relation to contracts with public authorities, governmental authorities, and more generally perhaps in relation to investor-state arbitration, where the rights and obligations of the public are being decided. And as I said, I'm not surprised, but I'm extremely pleased that he agreed to give the talk that he gave, and that he's given so much thought and so much original thought to his address today. So on behalf of everyone, Mark Lawyers, Chartered Institute, and all of the attendees today, thank you very much, Brett.
You're most kind. Thank you.
Thank you. We'll end the seminar and everyone can resume the rest of arbitration week here in Australia. Thank you, everyone.